Welcome to the Pregnancy Help Podcast. I'm Lauren Bell, and I'm joined today by Heartbeat International President Jor-El Godsey, General Counsel Danielle White, and Vice President of Communications and Marketing Andrea Trudden. This episode comes at a pivotal moment. On April 15th, Heartbeat International will be involved in two significant court hearings, one in California and one in New York, both centered on a critical question. Can pregnancy help organizations continue to share information with women about their options, especially in time-sensitive and life-altering situations? As legal challenges unfold and Supreme Court precedent shapes the landscape, these cases carry implications not just for pregnancy help organizations, but for the women they serve. Today, we'll break down what's happening, what's at stake, and why it matters right now. It's good to have you all with us today. Andrea, I'm going to turn things over to you.
Yeah, it has been quite an interesting couple of years for us here at Heartbeat International and then our pregnancy help organizations, both in New York and California. So we wanted to be intentional about taking this opportunity to say what is in stake as April 15th is nearing very, very close. And we have two court cases happening, both centered around the ability to talk about abortion pill reversal. However, these specific court dates are talking about it from two different angles. And so strategies are involved, and where we don't necessarily expect to get a decision on whether or not we can talk about APR, whether we can communicate it within our communities and things like that, they do have some potential for having some very major implications for the cases, not only in New York and California, but hopefully help set a precedent for other states, attorneys general nationwide. So Danielle, I want to start with you on this because as our general counsel, you definitely are the one I go to whenever I have a question in regard to one of these cases first, to be certain that we understand the nuances, because there are a lot of nuances that have been a part of the past couple of years. So to start us off, can you please explain what is happening on April 15th, coast to coast?
You don't get to pick the date for hearings. The courts just decide, and this is the date that two separate courts decided we were going to be having critical hearings. So I'll start with California first. Out in California, we are having a hearing on our summary judgment motion. So just to explain what a summary judgment motion is briefly, basically what both of the parties have done is they've filed motions telling the court why it's not necessary to have a trial, whether that's on all of the issues in the case or on certain issues in the case. And so summary judgment is meant to be a way to preserve judicial resources and prevent time-consuming and expensive unnecessary trials. The purpose of a trial is to determine the facts of the case. And so if the facts are all clear and both parties agree on the facts, it's not necessary to go through the rigmarole of a trial. And the court can just decide the legal issues. So Heartbeat filed a motion for summary judgment, arguing why it's not necessary for us to go to trial. And we've argued that no trial is necessary on all of the claims because we believe that our First Amendment rights protect our ability to say what we're saying about abortion pill reversal. The Attorney General filed for summary judgment on some of the claims, but not all of the claims. So the Attorney General feels that a trial is necessary to determine some of the facts at issue in the case. So that's what's happening in California. Going all the way over to the other coast, we in New York, we're in a totally different posture. So in both instances and in both states, the AG has filed suit against Heartbeat, claiming that our speech about abortion pill reversal is false and misleading. And these are under consumer protection statutes. In New York, we had the ability to file what's called an anti-SLAPP motion. We didn't have the ability to do that in California because of the way the statute was written. But in New York, we could. And an anti-SLAPP, well, it would help to explain what a SLAPP is. A SLAPP is a strategic lawsuit against public participation. And what that means is the legislatures were recognizing that there were instances where people were exercising their First Amendment rights and then being sued by those who didn't like the message they were speaking in order just to silence the message. And so if you think about a powerful entity, maybe a government, maybe a state government, but it could even be a corporation that has a lot of funds, they could sue somebody and make it expensive to defend that speech in court. And so it even though the party who's being sued might ultimately win, they're still going to have to pay attorney's fees, and they'll be intimidated. And so the states all across the nation, various states have passed different types of anti-SLAPP statutes. Some states have stronger anti-SLAPP statutes, and then some don't. But in New York, we felt that the Attorney General was using the legal system to try to silence speech that she disfavors, and that is a SLAPP. So we've briefed that issue, and coming up here later this week is our hearing on that motion.
And going back a couple of years now, where all of this began, the cases that are the catalyst for both of these are very much surrounding the ability to talk about abortion pill reversal. So I know that, thank you for that context for where we're going this week, because it is one of those nuances, like I said. But Jor-El, for somebody who is hearing about this for the first time, and I encourage anybody who is really interested, we have podcasts going back from the beginning a couple of years ago, talking about when we learned about California suing us, and then when we learned about New York suing us. Can you talk about kind of what this would mean for the movement, and why people need to be caring and watching these cases?
Yeah, that's part of the adventure. One, I think let's dial back. If someone is brand new to the conversation, remember that abortion pill is not one pill, it's two, and that there's an increasingly growing number of women who are regretting taking that first pill and seeking a way to alter the course that they had set themselves on by taking that first pill. And that is abortion pill reversal, which is just progesterone. Progesterone is a times-tested way to continue a pregnancy, even through miscarriage challenges. Abortion pill is really designed to create a miscarriage happening. And so this is a way that progesterone, high dose of progesterone, is able to essentially reverse the effects of the mifepristone, which is that first pill. And so at the time that we were actually sued by the state of California, there was already some existing action on abortion pill reversal as something being provided or prescribed in Colorado. So the effects of the new lawsuit was really not to go after the provision of it, but the promotion of it, which is why we're actually talking about what Danielle was keying into was speech. And so in some ways, this is actually kind of a pattern that California tried to do against abortion pill reversal years and years ago, which is a whole nother conversation about their nursing board and what they tried to accomplish. But it is really going to the promotion of it. So on the one hand, they seem to be not necessarily going after the provision of APR. In fact, the person that started the abortion pill reversal network, it was known back then, is a California doc. He's been doing it for years. And he's been promoting it. Dr. Delgado has been amazing. He continues to speak about it, continues to provide it. He's on our advisory team. But he was not the target of this particular action. It really is against those that are promoting it, which certainly Heartbeat International is doing that, not just in California, not just in New York, but around the country and even, frankly, around the globe. We've had, last I heard, we had 98 different countries where we've been able to step into someone's situation where they're trying to do something similar in an effort to help them attempt that process. And so this is really a big conversation, which is just kind of focusing in on the actions of one, or actually two attorneys general from what we now know are abortion states, right? So California is definitively an abortion state. Again, if you're new to the conversation, the Dobbs ruling effectively overturned Roe versus Wade, but rather than stopping abortion or even constraining it, it just moved the conversation back to the states, which basically puts us into kind of a dualism in our nation where you have life states, those that have moved to make restrictions against or constrain abortion in some way, in some cases almost eliminating abortion as a matter of law. But then you have the exact opposite thing happening, which is in abortion states, you've had states move to do more to, if not actually pay for abortions, than to actually protect abortion providers. They have shield laws. The post-Roe era has become really a political morass as far as between life states and abortion states. And one of the tactics that the abortion states are trying is to keep women from hearing the message about the fact that they can reverse their abortion.
So knowing that in California, Attorney General Bonta has sued us, and then in New York, Attorney General Letitia James has sued us as well. Again, from what you noted there, from promoting APR as a possibility, not the practice of it. That is still allowed, but talking about it. So I'm throwing this back to you, Jor-El. What do you think their attorneys general are trying to accomplish here?
Well, I have lots of thoughts about that. Usually they involve language that I can't speak on the air or shouldn't speak at all, frankly. But this is really a question of the abortion ideology. There's this thing that we've known for years. If you've been involved in the pro-life movement to any degree, or you've just even been an observer of it, you've watched an abortion distortion. And this is very powerful legal entities in the sense of the state, the state attorney, the attorney general of any state. They have very, very strong powers that they certainly can use to in their efforts to be part of the governance of their own state. But in this case, they're trying to reach even outside of their state. And that was one of the questions we asked early on: is like, hey, what does the state of California have the ability to reach into Ohio organization, which is Heartbeat? But that was set aside by the judge, and we continue to have these conversations. So it's really understanding that these are very powerful entities that are often politically motivated. We can see that big abortion, and by that I would say the likes of Planned Parenthood and many others who are of basically funding campaigns of elected officials. And guess what? In a state attorney general it's an elected official. I believe firmly that these are actions that are driven largely by ideologies, the ideology of abortion, the fact that it's a huge moneymaker, as we've seen. It's a multi-billion-dollar industry that reaches to affect not just local areas like California, but works around the globe and tries to help other people. And so for them, there's a huge profit incentive, and so the fact that we seem to, I never really fully understood why they go after reversal. Like, what do they care? They've already paid for the product. It's a woman just trying to change her mind. Like, why? But apparently, it's a big issue to them because it cracks into the narrative that abortion is good for women, and these women that are discovering, no, this is not really what I want to do, and they should have an opportunity to continue and the right to continue their pregnancy, and that is effectively what California and New York are arguing against.
We know that they are part of a group of about 16 attorneys general who have taken different strategies to try to silence or suppress the good work of pregnancy help. In both of these cases that we are a part of, they are including pregnancy help organizations that provide services as well, provide APR, or even just information about it. So hopefully, as I mentioned earlier, what does happen is this precedent is set in the affirmative that will help squelch additional strategies. We know that they may just shift just from history. However, it'll be a good win if in this case moving forward. And actually, knowing that when we put this on the schedule, we did not know that there was going to be a Supreme Court decision that may come into play. We don't know, but it could in the decision of Childs v. Salazar. So Danielle, going back to you, in simple terms, can you share a little bit about Childs v. Salazar and what the court decided and how that may come into play?
So Childs v. Salazar was a Supreme Court case decided very recently involving a California statute that prohibited licensed counselors from engaging in conversion therapy, which what that amounted to was a reality that a Christian counselor would not be able to help a client who wanted to reduce, or as the court says, reduce or eliminate unwanted sexual attractions, change sexual behaviors, or grow in the experience of harmony with their bodies. So if the counselor at issue in that case had someone come to her who wanted help with feeling more comfortable as a woman in her own body, the counselor would not be permitted to do that. So it really involved a very viewpoint discriminatory. That's the First Amendment buzz term, is when the court comes in and says, you can talk about this topic, but you can only talk about it in favor, or you can only talk about it in opposition. That's really the government putting their thumb on the scale because they're silencing one entire side of a debate. So viewpoint discrimination was definitely in play here, but even stepping back from viewpoint discrimination, the court is very, very leery of content-based restrictions on speech. So to kind of parse those out, a content-based restriction on speech would say, for example, we just can't talk about cigarettes or smoking, whereas viewpoint discrimination ban would be you can't say things in favor of cigarettes or smoking. So the court is leery of content-based restrictions in the first place, but then kind of the viewpoint discriminatory nature of the speech or the speech codes here was especially problematic. Childs, I think, is very informative for our cases because we would like to speak a message about abortion pill reversal that is in favor of this option for women. And we're being sued because we're speaking a message that's in favor of abortion pill reversal. On the other hand, if a speaker, like, for example, Planned Parenthood, wants to put on their website that abortion pill reversal is dangerous and untested, they're not being challenged in their ability to speak that message. So we think that the Childs case was very helpful, and we'll be very keen to hear what the courts do with that case in the hearings this week.
So Jor-El, what are your thoughts in regard to, if I can ask your initial thoughts when you heard the Childs v. Salazar decision, and then how it may relate to us? Is there anything else that kind of came to mind, or like, oh, this should be really helpful for the movement, or this has nothing to do with it? I know we actually input an amicus brief because we saw the benefit of Childs v. Salazar and the pregnancy help movement and freedom of speech and viewpoint and all of those fun things. But what was your initial reaction when we got that decision?
Well, for me, what I heard was a lot of conversation about the nature of professional speech and how in the past there have been delineations, and there continue to be, and probably need to be, clarity on when we're speaking such a way that our First Amendment rights are intact, and then when certain conduct is happening, and it feels like there was a lot of conversation in this case about the things that I was hearing around this that talked about how this was really about the counselor speaking and not so much the conduct of, for instance, in our world, like we would say, well, there's a difference, between the act of abortion, which is a violence to the woman or within the woman, versus speaking to her about her abortion. And the very nature of the lawsuit against us is simply about speaking about it reversal. And so we're not necessarily talking about conduct, we're talking about speech. And the state has tried to go through great pains to make what we do commercial speech. Never mind the fact that we don't actually receive any benefit or commerce from the nature of what we do. We're simply trying to promote this as a possible answer for her if this is what she's looking for. And so whether you're in California or New York or Arkansas or Florida, it shouldn't matter. We're simply trying to promote that this is a way that you can potentially continue your pregnancy once you've already taken the abortion pill. And so this to me is very much about speech and the nature of speech, and the fact that we of course should have the ability to speak the very potential for her being able to rescue the life that's in danger.
Well, that's important too, because the fact is, thousands of women have been able to find abortion pill reversal and the abortion pill rescue network by looking. Like, they're looking for it online. They're seeking it out. And so to your point earlier, Danielle, of being forced to only have one viewpoint online, it makes it possible that then she's getting no affirmation that something is possible, which our statistics show us. There are studies that show 64 to 68% and upwards of 80% of a success rate with abortion pill reversal. So women who are looking for a reason, or not a reason, but a way to try and save her pregnancies, this could hopefully keep that line of communication open so that she sees this as an option.
Another important point from Childs is, the state, especially in California, we haven't gotten super far into the arguments and the merits in New York, but especially in California, the state is really leaning on ACOG and saying, oh, ACOG has said that abortion pill reversal is not based in science. ACOG has this viewpoint. And so they're really suggesting that because ACOG thinks one way, we are not permitted to think or speak a different way. And in the decision in Childs, the court expressly rejects that. They say, I'll just read from the opinion, consider where the state and the dissent's logic leads. So that's, the state of Colorado saying that conversion therapy, quote unquote, is not permissible. Not long ago, many medical experts and organizations, including the American Psychiatric Association, considered homosexuality a mental disorder. On the view Colorado and the dissent advance, a law adopted during that era prohibiting counselors from engaging in the substandard care of affirming their client's homosexuality would have been subject to only rational basis or intermediate scrutiny review. So basically what they're saying is if we have to always defer to these professional associations and their viewpoint on medical issues, then first of all, it stifles innovation because we won't be allowed, if the minority viewpoint isn't allowed to explore their perspective of things and speak their perspective of things, then the medical science can't advance. And the First Amendment cannot allow for the silencing of a minority viewpoint in medicine. So that was really important from the case too. The case goes on to say, today, tomorrow, and forever, too. Any professional speech that deviates from current beliefs about the safety and efficacy of various medical treatments could be silenced with relative ease. And that's exactly what the California and New York attorney generals are trying to do. They're trying to silence speech about the safety and efficacy of various medical treatments of abortion pill reversal. So that's really critical.
By the way, ACOG is the American College of Obstetrics and Gynecologists, which is also an arena where the ACOG is known to be more not just leaning, but beholding to the abortion position. There's an entire group of pro-life obstetrics and obstetricians and gynecologists who basically had to start a whole nother organization. They actually tried to organize within ACOG because they were pro-life and they could see the path that ACOG was on, becoming more beholding to the abortion ideology. And so they tried to organize within ACOG. ACOG eventually said, nope, we're not going to have any special groups anymore. They actually eliminated the whole category. And that group that we know is APLOG, right? The American
Association of Pro-Life
Association of Pro-Life OB-GYNs, right? And we're grateful for them. They're great supporters and really champions for abortion pill reversal. So we're so thankful for them. But that just shows you like what Danielle is calling out is that any one of these entities that is captured by a certain ideology, like in the instance of Childs, like that, there's a whole lot about the gender identity and sexual orientation that has been capturing various elements. So, and you've seen this kind of thing. This has been going. This is the abortion distortion I was talking about earlier. It's affected many aspects of our society, of our academies, of our various organizations that have been supposedly gatekeepers, or they've been kind of given this status in our world. Some would suggest that they're even like a quasi-governmental status, but the truth is, like, they have their ideologies, and that's what our opponents in California and to some degree, like you said, we don't know all of the conversations in New York yet, but they're leaning on these very individuals or organizations who have this status, who have been, we would say, have been corrupted by the abortion issue or by big abortion and its tentacles.
Two quick notes before moving over to New York. In regard to ACOG, one of my favorite pieces that they have published a few years ago now was actually, I believe Doctors Grossman and Crennan were published in a report by ACOG about abortion pill reversal, though not named in that way, just talking about offering progesterone after an abortion or being given mifepristone. And they included a may increase risk of ongoing pregnancy for that. So it's like, okay, thank you for proving that progesterone may increase the risk of ongoing pregnancy.
Yep.
That was one that was just fascinating to see. So ACOG does know that this is a possibility in their own publications. And then a secondary piece that I wanted, we purposely put trials into the California side of things, because when we get to New York, we're going to get into the weeds on what that case involves. But it's important to note that with Childs v. Salazar, in regard to the viewpoint discrimination and the lack of ability to do that, the court, it was not like a split decision. It was an 8-1 decision in favor of First Amendment rights and freedom of speech and the ability to communicate. So I thought that was definitely worth noting there before completely pivoting here. So moving over to New York, this case is very similar. However, this hearing is about that anti-SLAPP motion that you noted at the very beginning. So Danielle, can you kind of refresh, what is Heartbeat and our pregnancy help organization friends? What are we arguing in this case?
Yeah, so let me just kind of start from the beginning, because this one is a little bit more technical from a legal perspective. Heartbeat and 11 pregnancy centers in the state of New York were sued back in April of 2024. Again, under those consumer protection statutes, the Attorney General is arguing that Heartbeat and our co-defendants are misleading women about abortion pill reversal, and they take issue with our speech about abortion pill reversal. So there were some technical things that went on as far as where the case would take place and jurisdiction and venue, if you're in the legal world and are interested in that kind of thing. But ultimately, we've landed in Manhattan, and the case is going to proceed in Manhattan. And before the case can proceed on any of the other arguments, first we have to address this anti-SLAPP issue. And one important thing that I forgot to mention earlier was that if if the speaker prevails on an anti-SLAPP motion, then the case is over. And the plaintiff, the person who brought the case, has to pay the attorney's fees for the defendant in many instances. So it's kind of, when you think about an anti-SLAPP statute, it's about trying to protect First Amendment rights from being kind of taken away in a practical sense, because a person is so afraid to speak their message because they don't want to be sued in court and then have to pay all of the attorney's fees to defend themselves. So that's exactly what's happened here. Heartbeat was speaking a message about abortion pill reversal. The Attorney General is very clear that she does not prefer our viewpoint about abortion pill reversal, and she sued. So that, in our view, is a classic SLAPP suit and should be dismissed on that basis.
So if the court grants the anti-SLAPP motion, what happens next?
If the anti-SLAPP motion is granted, the Attorney General would have the opportunity to appeal that. But assuming that we prevail and she doesn't appeal, that would end the case. The case would be done.
Completely. All done.
Yes.
All right. So that's the hope there.
Yeah. So if we do not prevail on the anti-SLAPP motion, then we would proceed to discovery. So that discovery is that fact finding, the parties exchange questions, interrogatories, and discovery requests, and then they exchange documents, and so that process has already occurred in California, has not happened in New York. So that's what would happen next in New York. And it's not a fun process, and we've kind of said all along that the process is the punishment. We think that these cases are entirely without merit, but what the AG gets to win, no matter what, is that they've dragged us through the harassment of litigation for nearly 3 years now, and the expense of litigation, the stress of litigation. And so, the process is the punishment. But we feel very confident that if this case were to proceed to discovery, we believe the facts are in our favor. And so hopefully that we can be spared from that that process that is a punishment, and it isn't fun, but we're not concerned about proceeding to discovery from the standpoint of we've got the goods. We're saying things that are true and non-misleading, and we have the First Amendment that protects our ability to speak our critical message.
And honestly, we're very confident that we will win on the merits, like the merits of the actual science of the things that they're disputing, because in California, they're making the claim that we know that what we're saying is fraudulent, and that there's nothing further from the truth. Like we've not only seen it as a powerful opportunity for that woman to make that change of mind and change of heart and pursue a different path, but we've seen the success of it. Like we've had very good conversations with very little children who are delightful to be around, and some of them are actually a little older now. Like the oldest the oldest that we know of is turned 18 this year, right? And so this is not just about little infants; it's about lifetimes that proceed from that moment where she makes that change and begins to move forward. So this is a very important conversation, really, in the matter of discovery. It's all for the idea that we will have our day in court and prove, in fact, that the science is on our side. It does affirm and confirm what we know, and we want to continue to speak to women that, yes, there is a chance. It's not 100%. We've never represented it that way, but there is a good possibility that you can continue your pregnancy even after you've taken that first pill. And so these are things that we want the chance to stand in court and to defend, and to be able to declare these with confidence, and not be harassed by government officials who are working with taxpayer dollars in order simply to try to push a narrative that they don't like being spoken out of the public spotlight. Like that, to me, is the very definition of what Danielle is talking about when she says a slap motion. Like, I would like to slap somebody, but nevertheless, this is one of those things. What we think we should win going away, and there shouldn't be an issue. But again, we're dealing with an abortion distortion where even judges find themselves supporting abortion when they really shouldn't.
And you brought in the stories. So we are further down the road in California than we are in New York. And we did have several mothers go on the record. And so, Danielle, would you mind kind of sharing a little bit about what the mothers were saying? And they were in our favor, because these are women who were served and were able to have that chance to save their child and save their pregnancy. But multiple women went on the record. So tell us about that and the impact that has within depositions and in the case.
Yeah, it's a really unique thing when you're looking through declarations that are filed in court and you get to see baby pictures. That was just a really special moment as I was looking through all of the declarations from our APR moms. I sat in on all of the depositions where the APR moms shared their testimony. And one thing that really stuck out to me is when they were asked what they felt when they found our resources, it was unanimously hope. These women felt hope when they found our resources. And so they all, each of them have their own beautiful story to share. And each of them has a child now because of abortion pill reversal. And so it's a really beautiful thing. I think that, we spoke a little bit earlier about like motivations, but for the AG, it's hard to really know exactly what motivates anybody, but I think it's very telling, the very first line of the complaint. So the complaint is the document that starts out the whole lawsuit. And the very first line of the complaint in the state of California is, for the vast majority of pregnant people who choose to undergo an abortion, their most common emotion is relief. And I don't think any of those women who filed declarations in our case and testified under oath would say that relief was what they felt from their abortion. So I think that it really gives the lie to the very first line of the complaint, right? How strange to start out your complaint saying that most people feel relief, because they're complaining about an option that someone would pursue if she maybe doesn't feel relief. So those stories are just so important, and I think those women who shared their stories had every right to hear the information that we have to offer, and I think they had every right to choose not to finish their abortions.
And we have one joining you this week down at the hearing too, because she's not speaking. She is just that into it and wants to hear and be present and be a part because she believes so much in championing this. So, Jor-El, what happens? We don't know how the cases are going to go, but what happens if information about abortion pill reversal becomes harder to access? What if California wins?
Well, that's a just a terrible thought even to think about. But frankly, if the court allows the state to silence Heartbeat's message about APR. And it's not just Heartbeat, by the way. It's pregnancy centers all over who have jumped on and said this is so important. We know women that are facing this. But if the court allows the state to silence Heartbeat's message about abortion pill reversal, then women will be forced to actually complete abortions that they no longer want, that they're trying to withdraw their consent from. Like we've heard this word consent so important about anything involving reproductive rights, sexual activity, and yet here's the state actually pushing away a woman's right to withdraw her consent from an abortion she no longer wants. So it's a critical thing. It's something that the state should not be allowed to do, frankly. And obviously, if we were to not come out favorably in the at the lower court level, we would of course appeal this because a woman should always have a right to continue her pregnancy, and overcoming a decision that she now regrets, as long as it's possible. That's one of the things that I was chastised even early on by an APR nurse who heard me talking about it, because I made the mistake of saying something that's like, well, we didn't really, for those for whom it's not successful, we didn't really help her. And she said, Jor-El, you need to understand, even you've given her something that she can always cling to after the fact, that she did try something. She tried to correct that decision. So the court would be stepping in and really doing a disservice to the women. So really, it's about her having the right to continue her pregnancy.
Exactly right. Thank you very much for putting that so succinctly. So, as we kind of close out, I know we're going to be watching a bunch of things. The California hearing is going to be viewable. And so we'll be tapping in for that. Again, we have people on the ground both in New York and California. So we will be keeping things up to date at pregnancyhelpnews.com and then on our website, heartbeatinternational.org. But beforehand, Danielle, I want to start with you and then move over to Jor-El to pick up on this. How can people be praying for us in this?
Please pray for the attorneys who are litigating this case for Heartbeat. Pray for wisdom, that they would be able to answer the questions really well and make our arguments really well and effectively. And please pray for the judges to also have wisdom and fairness and courage. Both of these judges are in very blue areas, and it would take courage to go against kind of the pro-abortion sentiment in those particular geographical locations. And so please pray for them to have the courage to be just.
Yeah, justice is supposed to be blind. I always wondered, like, I never understood the statue until someone explained it to me. Like, why is the lady with the scales have a blind over her eyes? Because she's not supposed to be swayed by things that are in the culture or things that are in the political realm. She's supposed to simply judge on the merits of the case, and that's where we expect to win. So yes, pray for righteous judges to rule from a place of righteousness, not one that is responsive to the very forces that Danielle was talking about. A couple of things. Keep in mind that this is not just about Heartbeat. In the California case, there's a very real pregnancy center with very real services who have actually been on the abortion pill rescue network longer than than Heartbeat was running it. They were on it before that. They were part of that early wave of pregnancy centers that saw the reality of this. And so pray for them, pray for their team as well. They have a lot at stake in this also. In New York, it's actually bigger. There are 12 other organizations along with Heartbeat who are part of this. So pray for each of them. Each of them is facing some challenges should this not go well. And we're in it with them. We're in it for them. And so we want to pray for everybody involved. It was a mighty accomplishment to get all 12 boards involved, plus Heartbeat's board, to move quickly in the New York case to actually, as someone said, big firm them. Like, wow, I didn't realize that was now an adjective, right? That was able to be used. But that's exactly what happened. We're grateful for each of them that are in this, and we need to stand together. Surely if we don't stand together, we will hang. If we don't hang together, we'll hang separately, as Benjamin Franklin quoted of our nation early on in its years. But this is something where each of these organizations are taking this on, not just for themselves, not just for the women in the area, but for those that are in these states, and frankly, for those that are across the nation in states that are governed by the abortion lobby, in a sense, the AGs who are influenced by them. So this is a big point of prayer. It's going to be a big decision either way. It's going to be important for us to keep before the Lord. We know that we've had some really good lawyers involved in this, and we have some very strong and faithful leaders who have said yes to take this on, carry this cross. But we need them to be upheld in this in prayer on this particular day.
I think primarily too that the truth does prevail, because
That's right.
on the one hand, it would be great if in New York we win the anti-SLAPP motion and then it goes away, and then in California we win on the summary judgment and then that goes away because it's now proven, like, oh no, these aren't worth bringing because of the cases. However, as you noted earlier, Jor-El, like, we kind of want to go in order to be able to say, no, prove it. We are telling the truth. We are helping women, and they have been saved by this option, and it is not hurting. And to kind of have that aha moment within the states, and then a longer term impact, hopefully. So yes, we just pray that truth prevails throughout this all, one way or another. So we're excited for where it's to come. So as we look ahead to April 15th, there are a few key things to keep in mind. In California, the court's considering whether the case can be decided now without going to trial. In New York, the court's deciding whether the case should move at all or whether it represents an attempt to silence protected speech. Both hearings are different in their legal posture, but they point to the same underlying issue. Who gets to speak, and what information is a woman allowed to receive in one of the most critical moments of her life? And that's really what it comes down to. You can stay up to date on the hearings at pregnancyhelpnews.com and learn the background of each case at heartbeatinternational.org. Thank you so much, Danielle and Jor-El, for your time today. It's always fun to get with my colleagues and being able to share inside baseball. And we thank you for joining us on this important conversation on the Pregnancy Help podcast. This is a moment that matters, and we're grateful you're paying attention to it. Thank you so much.